to trump the exercise of power by the assembly of NCT. I am saying this. He is not saying it, I am saying it. With deepest humility, Minister. Your Lordship is given a picture as if somebody is hijacking the national capital. Then, kindly see how they understand the word state. Kindly go on. Just like the earlier rules, Manus, state is the only word used. UT is not used, but they understand it to include UT. Then, Manus, may I, with your Lordship permission, skip 3, 4, 5 and 7A? May I skip that? Kindly come below 7A, just the next page. For the schedule, the following schedule shall be substituted. Schedule. Composition of Civil Services Board. Every state government shall constitute a Civil Services Board which shall consist of Chief Secretary, Chairman, Senior Most Additional Chief Secretary, Board Revenue, Financial Commissioner, etc. rank, Member, Principal Secretary, Department of Personnel, Member Secretary. The Civil Services Board shall make recommendation for all appointment of cadre officers. This is the Civil Services Board functioning in Delhi. Where does it come from for a union territory if you read the state technically? The Civil Services Board shall examine the cases of officers who are proposed to be transferred before completion of minimum period. They have always understood the UT to be included in all these rules, even though the word state is mentioned. They are having a Civil Services Board. It's a different matter that he exercises the power and doesn't allow me to exercise. But the Civil Services Board is here.
Just technically, I read this yesterday.
That's all right. I'm giving the submission.
It's not as if this was.
I'm not saying you suppressed it. I'm saying
Yes,
I'm giving an interpretation.
Just the proviso clause 5, it's an advisory body.
Of course, Balu, the Civil Services Board, like everything else, is an advisory body. It makes suggestions. The government can always accept. This covers my para 11.
LG. That was my submission.
No, that obviously advises the LG or these NCT government, but it will be a later issue. Now, I have done with this point, and you'll also come back to yesterday's rejoinder. So these are the 2 points related to para 3. I'm sorry, Manu, the Lordship may make a mark in para 3 of the yesterday's submission that they should be read with 11 and 12, which my Lord has just read. I now come to my yesterday's rejoinder note to para 4.
Yes.
Now your Lordship asked me that question on 309. Yesterday I said, I answered it, but I said I will be coming to it later in the note.
Yesterday's note.
Yesterday's note, para 4.
Scope of entry.
Correct. Scope of entry 41, list 2 is wider than the scope of the proviso to Article 309, and any executive action under 309 does not limit the power of the legislature to make laws under entry 41, list 2. That's the head proposition. Before I read that, may I itemize the points here? It will be easier than reading, then I'll read only one part. The points which I said yesterday need to be itemized now. A. I'm repeating, but I'm itemizing it under this section. The Constitution. 309 starts with subject to the whole Constitution. And necessarily, Malus, our special part dealing with 239 AA, etc., is part of that Constitution. And 309 is subject to that, to the entire Constitution. It says subject to this Constitution.
239 also says subject.
No, it says in only one clause. Not in A. I checked. 3A. Only in 3A. That's the point. My Lord is right.
Yeah.
These points you have enumerated here, or you're now
Well,
just...
it is here, but maybe not with that particularity. That's why I'm asking Lordship to just ABC only 3 points.
All right, just tell us.
It's not in this form. A, subject to the Constitution, just a general point, I'm not relying only on
Subject.
is the opening word of 309. Subject to the provisions of this Constitution, comma, acts of the appropriate legislature, etc. So it's even acts, subject to. Second, B. Prem Kumar Jain was a direct case in the same part, 14, same chapter 1. 3 sections apart in 312.
Yes.
For 312, 4 learned judges of this court, which has stood the test of time, held that duty is covered and subsumed. In that case, the UT of Himachal and Delhi were held to form a joint cadre, reversing the High Court, which said, because they are duties, they are not covered under the word state. So, Malus, the C point is that it has been already decided by your lordships that duty is covered, albeit in a case arising under 312. D. Absent, Malus, any special provision of this chapter or this part, your lordship will never read 312 to include duties and 309 not to include duties. As simple as that. As legislative power. It would be a very startling result unless your lordship were forced by some language to do it.
3122.
D is, I've dealt with C, which is for 312. Absent specific exclusionary language in the constitution in this chapter, your lordship will never read duties to be subsumed under 312 as Jain holds, and duties not to apply to 309 as my learned friend, the solicitor, argues. Imagine the startling consequences of that kind of interpretation. So now I come to the speed. They are the 4 points which are not put in this form. So the lordship is kind enough to me. Now, the lordship will read EF from this 2 paras only, from this note. That can be E and F of your lordship. So EF and G in continuation, same section. This is on the width of entry 41 being larger than 309. Para means 4. I.
So the additional rejoinder point, I have only para 12, up to para 12. Maybe mistakenly not.
14 is there.
Yeah, it's there at page 3.
But just hold on, I'm not raising any objection. I'll take a copy. The copy I received ends at para 12.
My lords have got it wrong.
No, on
Here.
I have got only up to para 12.
Well, that's what I also got up to para. Therefore, I just.
My deepest apology.
Now, hard copy I have got.
This is vital for me. I don't know how your lordship. One Senate has got to go. You have a copy now.
The morning, so maybe by.
No, it is only there. Up to para 12. Anyway, I have got it.
My apologies.
It's okay.
I'll send your lordship. The other one is already there.
Please do. Yeah.
Actually, Dr. Singhvi, you can read this para. I was also reflecting on it last night. See, the entirety of list 2, there's a legal fiction which we have to, as we always say, you shouldn't allow your mind to boggle. There is a legal fiction. There's a legal fiction in 239AA, as a result of which the entirety of list 2 of the 7th schedule is basically a concurrent power.
Is made like a concurrent.
Is made like a concurrent power in relation to the UT of Delhi. So Parliament can legislate on the entirety of list 2.
Just like the state can also, or the UT can
Right?
also.
So that's the effect of it. Now, if Parliament can legislate with the entirety of list 2 in addition to list 1 and list 3, then Parliament has the power to legislate under entry 41 of list 2 also. Now, if Parliament has the legislative power on entry 41 of list 2, then there is no reason to take recourse to entry 97. You take
That's the short point I am making.
you take recourse to entry 97 and article 248, which
Not
is
wrong.
residuary power, where there is no provision elsewhere.
Very great respect, but I can't put it more pithily.
Because both the judgment in Dillon's case,
Which is
has been
cited in the
followed,
cases I have
which was
quoted.
followed in
Dillon is cited.
Pritlal's case here, it says that in deciding as to whether Parliament has legislative competence, you ask yourself only one question. Is there any entry in list 2 which covers the field? if there is an entry in list 2, then Parliament has no legislative power.
That is that.
If there is no entry in list 2, then Parliament has to have power either under list 1 or list 3 or entry 97. That's drill. That's the residue power.
That's right.
But here, Parliament undoubtedly has powers on entry 41 of list 2 because of the
It's a
fact
concurrent
that it's
list.
in power.
It's a and therefore, just it'll take less than 2 minutes. What your lordship has put, very interesting, Dhillon, from two perspectives. One the negative, one the positive. I've given two cases. Just give me 2 minutes of that. I've missed out para 13, which I'll come to after. Just come to 14 first.
Yes.
Just, it's one para each, your lordship need not go to the judgment. Just read from here. Be that as it may, I'm straight away coming. This is the reverse. In my favor, but in the reverse context. Just read it. In my favor, reverse context. 39AA provides adequate checks and balances for protection of national interests in the NCT of Delhi. This has been repeated so many times. Capital NCT Delhi. Look at this, fellas. The Constitution provides. What more protection can Lordship give than give Parliament the entire list 2 as a concurrent list? Can a Lordship give any more protection, Manas? The boss is Parliament, if I may use colloquial words, Manas. Nobody is denying that. The issue is absent Parliament exercising contrary power, contrary legislative power. Somebody in the concurrent list can't exercise the same power, in this case a UT. That's the issue. Now read this. A conjoint reading of 239AA 3 and 4 posits that the conscious scheme adopted by Parliament in exercise of its constituent power, that is by constitutional amendment, is that the legislative power and concomitant coextensive executive power of the NCT, obviously not concerned with those 6 entries, can be legislatively overridden by Parliament. It's as simple as that. All this was national security, capital of India, nothing. Parliament needs to make a law or an existing law needs to be applied to trump the exercise of power by the Assembly of NCT. I am saying this. He is not saying it, I am saying it. With deepest humility, Manas. Your Lordship is given a picture as if somebody is hijacking the national capital. Then, the union is seeking to obliterate. Now, this is very important. This is a nuance. It's a jurisprudential nuance which I am submitting for Lordship's kind consideration. There is a difference between Parliament and the central government. My problem is my learned friend is reading Parliament to be the central government. That is my problem. That is where the nub of the problem arises. Parliament, your Lordship has given power to trump everything. He says central government should trump. What is happening in this case? The notification impugned is a central government notification. That is not Parliament. Please exercise your parliamentary power. The union is seeking to obliterate the distinction between Parliament and central government. Under the present scheme, the Assembly of NCT has full play in any unoccupied field of an entry in list 2. Acceptance of the union argument and upholding of the impugned notification would effectively endow the union government with an executive override. Your Lordship gives him parliamentary override. He gives to himself executive override by the impugned notification, which I have said is nothing more than adding 41 to 1, 2 and 18 by executive order. That's the simple number of this case. Endow the union government with an executive override over the Assembly of NCT. This is clearly opposed to the fundamental scheme of 239AA. It must be borne in mind that both legislative and executive checks that govern the exercise of power. 1. The entire list 2 for NCT effectively works as a concurrent list. Exactly what my Lord just observed. I am saying so myself. And this, well, I say what I am saying is, of course, subject to my Lord's, harmonizes the whole thing. What he says, well, will create a discordance. Because executive override of Parliament, of central government, can never be envisaged with a parliamentary override. The entire list for the NCT effectively works as a concurrent list. If any law made by Assembly is in conflict with a parliamentary law, the same can be reserved for consideration of the President. That's another Lordship knows concurrent list procedures. Further, in terms of the functioning of the executive, there's a difference power to refer. That's a separate one. Let's not get into that. Well, I only remains for me to thank your Lordships for a very patient hearing for both of us. Respect constraints. May I end, Malas, in pre-independence times, Malas. Long before independence, Malas. The British still used to call it the Indian Civil Service. So Nehru made a very interesting comment. He says, it is neither Indian, nor civil, nor a service.
At that time.
Well, as my submission is that at the end of this case, it is vital for your lordships to demarcate black and white the powers. Otherwise, well, as it will be either less of a service or less of civil, it will remain Indian. Deeply obliged.
Thank you.
Lord, immensely, Lord, for more than patient hearing.
Thank you, Mr.
We are
President.
immensely,
I have only-
all your,
I've done it within 1 hour, Manoj. I want to repeat that.
No, you
Get
absolutely
some
were
brownie
not
points
one
for
hour.
it was a learning experience, my lord.
Thank you, Mr. Lister. Thank you, Dr. Singh.
Thank you, everybody.
Very deeply obliged.